Hello everyone. I'm feeding back. Can you hear me okay? Good. Right. Good to see you all. Thank you for having me. I'm Paul McGough. I'm a partner at DAC Beechcroft Solicitors. What's a solicitor doing here, you might wonder? I give legal advice to NHS organisations, providers, hospital trusts, mental health providers, commissioners, do a lot of community care work, a lot of inpatient hospital medical treatment work. That's my day-to-day, and I've been asked to come and talk to you today about managing complex, self-neglecting patients. And I've been given half an hour to do that, when I could spend quite a few hours talking to you about that, although I'm not sure I've got your consent to me doing that. So what I've got to do is try and tackle this tricky topic in half an hour. So wish me luck. The way I'm going to do it is I'm not going to give you a kind of comprehensive overview of the topic. I can't do that. What I'm going to do is give you a case study and talk you through a real life case that I've been involved in which I was giving legal advice to a CCG. Remember them? It's about three years ago this was. I was giving legal advice to a clinical commissioning group about a challenging community situation, which I'm going to talk through with you, and you'll see as we go through, some themes are going to develop. I'm going to develop some legal points about how you go about managing these kinds of challenging situations in the community with vulnerable people who need help, need support, that otherwise is quite difficult to give to them. And we'll see, as we go through, we'll see who's involved in that process, what legal issues are in play, and also we'll talk a little bit about where you might come in to this. So that's how I'm going to do it. The success or failure of this presentation is going to rely entirely upon you, because I am not going to stand here and just talk to you for half an hour, because that would just be deathly boring. So please, I'm going to ask you questions as we go through. I'm going to put stuff on here that I hope you will discuss with me, and we'll go through it together. We'll develop the points together to get to where we need to get for this patient. No pressure, but please help. Okay. So I'm going to introduce you to Mrs. A. As I say, this is a genuine case. It's a case I was involved in about 3 or so years ago, and it is what we in the profession call a reported case, which means that the judgment eventually went to court, and the judgment is publicly available. And if you see these slides in due course, there is a link to the judgment later on, so if you want to go and read a bit more detail about it, you can. Mrs. A is a 76-year-old woman living in her own home with social care support, so she's getting care visits. I can't remember how many a day, but a few times a day she's got carers coming in to give her some help. The carers report significant self-neglect and wandering and failure to appreciate risk. They're worried about it. And remember, they're not there all the time. They're coming and going. So when they're not there, they're concerned about the risk that she may be at in her own home. There are concerns for her well-being, and the question then arises, I'm not going to say who's mentioned it, but we'll see where we go with that. But the question arises as to whether this is all really safe for her. She's living in her own home. There are issues around self-neglect. If I remember it rightly, there were concerns about her diet. She wasn't really eating very well. They were concerned about, it's clear there, wandering, failure to appreciate risk. The carers are concerned that when they leave, they'll come back and they'll find her injured and harmed. So, first thoughts. Who wants to bravely come in at this point? Let's imagine you're presented with this scenario. A hand has gone up right at the back of the room. That is brilliant straight away, but you're very far away. So, first thoughts. Yeah, let's hear your first thoughts. Delirium or dementia. Hold that thought. Okay. So we've got somebody bravely is diagnosing already. So yes, Kitty.
My first thought was safeguarding.
Safeguarding. Okay. And what does that mean?
So in terms of the woman having care and support needs, that's the first part of the criteria in the Care Act.
She's got care and support needs. Yeah.
Is she at risk of abuse or neglect? And that includes self-neglect. And
yeah.
Can she protect herself? So I'll be considering whether I need to start looking at that from a self-neglect perspective.
So you're thinking about making a safeguarding referral, are you?
Yep.
Into the local authority on the basis that she's at risk in terms of her self-neglect, and she's got Care Act eligible needs, and the looks of it, so you're going to make a referral into social services in terms of the safeguarding function. Okay, good, thank you. Yes?
What does she think?
What does she think? That's a really good point. Glad you're here. What does she think? Well, we're gonna find out in a moment what she thinks. So we've got some good points there around. Yeah, another hand up as well. Yes. Who does she live with? Right, another really good point. So we're going to come to this in a moment. At the moment, she lives on her own. At the moment, she lives on her own. Okay. So we've got a few things going on there. Somebody's asked about what she thinks. We've got a question around whether there's a diagnosis, dementia or delirium, I think it was you said. Gentleman at the back, yeah. Okay. And safeguarding referral. I think the safeguarding referral point is a really good one, and I would definitely be doing that to get the local authority involved from a safeguarding perspective. But bear in mind, she's already got carers going in, so the local authority are already involved in this case to some extent. There's been an assessment of her needs and community support is in place. The local authority are concerned about this for obvious reasons. They propose that she may not be safe in her home, and maybe it's better in all the circumstances for her to live somewhere else. They're proposing a residential care home for her. But she is firm that she doesn't want to go anywhere else. She wants to live in her own home. This is her home. This is a home that matters to her. She's lived there for a very long time. She's had all her children there. And this is a lady who's had a few children. They've all grown up and moved away. But that's the home that matters to her. So, what do we need to think about now? Yes?
Well, her mental capacity,
Right.
any sort of pre-morbid, I mean, assuming this is a new thing that's come on, did she have any previously expressed wishes? Had she got an advanced care plan, respect form, all these type of things?
This is like a textbook answer I'm getting over here. Mental capacity, pre-morbid or wishes and feelings expressed when having capacity, okay? Advanced decisions or advanced written expressions of wishes and feelings, absolutely, okay. That's really good, thank you. Yes, at the back.
Is her behaviour putting anyone else at risk, or is it just
Right.
hers?
I can give you the answer to that. It's a really good question to ask. Yeah, is anybody else at risk in this situation? In this situation, no, only Mrs. A is at risk, but it's a very good question to ask. Okay, so mental capacity has been raised, yes?
Is this a new change, or is this been ongoing gradually and progressive?
So is this a new change, or has it been ongoing gradually or progressively? I can't remember what the answer is in the case. I think it's been progressive. But she certainly, I think over time the concerns have been increasing about her. So, mental capacity was raised a moment ago. We've had people talking about what she wants. We've had people talking about whether she may have some form of diagnosis such as dementia, and wishes and feelings. So, we're in the realms of bearing in mind that there is a proposal of a move to a residential home, and she does not want to go. So we're in the realms of consent and thinking about mental capacity, absolutely right. Now, consent in a care or treatment context, so social care or health care, must be given voluntarily, so freely, without any pressure or any undue influence on the person, if it's to be valid consent. It's got to be given by a person with the requisite mental capacity to make the decision. And it's got to be based on sufficient information about what is proposed. So adequately informed, freely given, and capacitous. So the risk is, of course, that if you do something to a person without first, what did I do? Get too close to this? Okay, stand back a bit. If you go ahead with a proposal that the person has not already consented to, you risk potentially assaulting them if it involves a laying on of hands, or at least it's an infringement of their rights, and their human rights come into play under the Human Rights Act. The Human Rights Act is engaged here. We'll be talking about somebody's Article 8 rights under the European Convention on Human Rights. That's the right to a private and family life. So you've got to go about this in the right way. And normally we need consent And the issue here, of course, is that Mrs A is not consenting. She's at risk. We propose something that we think would be better to keep her safe. She's not agreeable to it. So we have to embark on capacity assessment. And this is probably the densest legal bit of these slides. Apologies now for turning into the lawyer that I am. But this is what the Mental Capacity Act of 2005 has to say about mental capacity. Can I take it that you're all at least reasonably familiar with the Mental Capacity Act?
Yes.
Thank you for bailing me out. Yes, okay, we've got some yeses. Good. Okay, so this will be reasonably familiar to you. You've got key principles in Section 1 of the Act, which we have to apply when we're dealing with somebody like Mrs A. In fact, anybody when we're considering their mental capacity, but Mrs A as much as anyone. So, first of all, she must be assumed to have capacity unless it's established that she lacks capacity. So our starting point is that we've got somebody here who's able to make her own decisions about her health and her social care and about any particular proposal that we put to her. That's the starting point. Now, there may be evidence to suggest that she lacks mental capacity. So we've got to go through an evidence gathering process then of determining whether she does or she doesn't, and is she able to make these decisions for herself. If you're proposing to do something to somebody and you think they may lack capacity in respect to that decision, the burden is on you, the proposer, the decision maker, to show, to demonstrate on assessment that the person can't make their own decision before you do anything else for them. It's on the balance of probabilities. You've got to be satisfied on balance that the person lacks capacity. And I've put a point there which is really worth emphasising actually. The presumption of capacity is hugely important. We talk about it all the time, and you must always start from an assumption that the person has capacity before you deem them lacking it, even when you're really concerned about them. It's really important, but it's no substitute for professional curiosity. So although you may think that the person has mental capacity based on the statutory presumption, think about it. There can be cases where somebody presents really well, presents really convincingly, but actually on a thoroughgoing, on a subtle assessment, you may begin to wonder if they've got mental capacity or not. And it's worth, the presumption is really important, but still ask yourself the questions around whether this is capacitous decision making or not, just in case a vulnerable person goes without support that they might need. So it's a bit of a fine balance in some cases. So we've got the presumption of capacity. And a person's not to be treated as unable to make a decision unless all practicable steps to help them to do so have been taken without success. So we've got to assist Mrs A, support her as far as possible to make her own decisions about this before we determine that she lacks capacity. So that's another burden on us, and it's a significant one. Importantly, a person is not to be treated as unable to make a decision merely because he or she makes an unwise decision. So Mrs A is at liberty to make unwise decisions, or what we may think are unwise decisions, as long as she has the mental capacity to do so. And an unwise decision does not mean that she lacks capacity. We have to go through the assessment process to determine whether she lacks capacity or not. So, when we assess capacity, we're talking about the material time, the time when the decision is required. We're talking about the particular decision that the person needs to take. We assess their ability to make that decision at the time when we're asking them to make it, that decision. And we're also concerned with whether there's some form of mental impairment or disturbance that may be making them unable to make the decision for themselves. So it's decision specific, it's time specific, and it's rooted in, if they're unable to make their own decision, there's a causative element where we're looking for an underlying mental impairment or disturbance. We were talking about the decision that needs to be made, the time it needs to be made, being able to do it, and if you're unable to do it, what's the reason for that? Is it because of an impairment of, or a disturbance in the functioning of the mind or brain. Capacity is assessed using this 4-stage test about understanding relevant information, retaining it, using it, or weighing it in the balance to make a decision, and then being able to communicate that decision by any means at all. That's the functional bit of capacity, that's the decision-making bit. Can you or can't you make a decision? And then the second stage involves identifying the impairment or disturbance in the mind or brain and showing the causative link between the two. That keeps happening as well. Gremlins today. So, a question for you. If that's how mental capacity works, and we've got a question here, haven't we, around Mrs. A's ability to make this decision. Who should be assessing Mrs. A's mental capacity? I'm not asking for a volunteer, this is 3 years ago, so we're finishing.
Well, anybody really. I mean, anybody who's skilled and has the knowledge about
Okay.
capacity. It doesn't have to be a clinician. Ideally, it's somebody who's has some experience in doing so. But yeah.
Somebody with the requisite skills, basically, is what I think what you say. There we are, okay. Somebody who's skilled, trained in the Mental Capacity Act, able to do it, okay. Is there any particular requirement for it to be a doctor, or any particular kind of doctor, or any particular kind of professional, do you know? I'm hearing a few no's. That's true. There is no requirement for it to be a particular kind of professional. There's a whole range of professionals that could potentially do it. And it does mainly come down to having the right skills, understanding. Am I doing something wrong? I'm going to try standing over here. Understanding the capacity test and applying it correctly. Well, there is a crucial element to mental capacity tests, which is often overlooked. Can anybody think what I might be referring to? It's not only about having the right skills, it's about presenting the right information to the person. So remember this, that if you're going to give valid consent to anything, you need to be informed about what the thing is you're consenting to. So whoever does the capacity assessment has to be somebody who is not only skilled in doing so, but is also able to explain the decision in enough detail. And it doesn't have to be micro detail, it's got to be the salient points. So what the Act says is the reasonably foreseeable consequences of deciding one way or the other, or not making a decision at all. So reasonably foreseeable consequences, and that's the test we apply to all of these capacity assessments. So it's about those two things, having the requisite skills and understanding and being able to explain and answer questions about the decision and give enough information about it. So in this instance, her capacity is assessed. I think her capacity is first assessed by a social worker, and then there's also a psychiatric assessment as it happens, because there is concern about how she's presenting and what that may mean diagnostically. So the decision in this instance is where she should live and what care she should receive. Because remember that there are concerns about her well-being, concerns about her not receiving adequate support, maybe, or not being able to support herself in some regards, and also being unsafe in her own home. So those are the key decision-making domains that we're looking at for Mrs. A. The conclusion is that she lacks mental capacity in those regards, in relation to those particular decisions. Going through that test, understanding, retaining, using and weighing, communicating, and then looking also at the causation element. Is there an underlying mental impairment or disturbance that impacts her decision-making ability? There is. It is, you guessed it, a dementia. So late onset vascular dementia, but in this case it's also complicated by agitation, an anxiety disorder and psychosis. So there's quite a lot going on with Mrs. A. What next? Now that we've established that, what happens next?
Does the best interest come as well?
Ah,
Do you have LPA or
that's a good question.
next of kin?
That's a good question. So you said LPA. So the first gentleman said best interests. You know, where does best interest come in? Okay, we'll come back to that in a moment. But a question's also been asked about, does she have an LPA or was it next of kin, I think you mentioned? Yeah, okay, yeah, fine. So, and another hand's gone up there.
Are any of those things treatable or reversible?
That's a really good point as well. Okay, I'll deal with these in reverse order. So treatability and reversibility, yes, you've absolutely got to take that into account, because it may be that she could regain mental capacity in order to make her own decisions about her situation. So that is absolutely got to be thought about before you march in and then start removing her from her home and changing her life. You've got to think about whether she could get better, at least make her own decisions. I can give you the answer in this case is no, it's not reversible, it's not treatable. Sometimes it is, sometimes it's really not. An LPA would give somebody else the right to make decisions about her in these kinds of situations where she's lost mental capacity, potentially. So that's a lasting power of attorney, giving somebody else decision-making power. They then become the decision maker when she's lost capacity. But I can tell you there's no LPA here. And next of kin is valid insofar as it's not a legally appointed role, it's not a formal legal role next of kin. Family members don't have any formal responsibility or decision-making power, except they are people to talk to about determining what's in the person's best interests. And that point you made about best interests, where does that come in? Well, it comes in here. That's exactly right. That's where we're going next. So we have to think about then, if she lacks capacity, what's in her best interests? And the fourth key principle of the Mental Capacity Act is that we've got to determine what's in her best interest, and we've got an obligation to carry that through. But it's got to be based upon the principle of least restriction. So we've got to do what's in her best interests, but in the least restrictive way possible for her. And there's an assessment process we've got to go through, having regard to Section 4 of the Mental Capacity Act, which is on the slides, but I'm not going to go through it in detail, about how you go about making a best interest decision for her. Crucial to that will be to take into account her own wishes, feelings, beliefs and values, which a couple of people have touched upon so far already in this slot. So both before she lost capacity and now whilst she lacks capacity, all relevant, and at the moment she's saying she wants to stay in her home. And we've also got to consult with people close to her, whoever they may be, for their views about her best interests. Who's the decision maker? It's GPs, right? The GP definitely should be making this decision. Yeah? Is that controversial? I can hear a few agonised no's around the room. Well, I think you've got social services involved in this case. They're already providing some care into the home. It doesn't look like she's eligible for continuing healthcare. And so it would normally be the local authority that leads on this process. So, what happens next? Is it that the local authority deems in its infinite wisdom that she'd be much better off in a nursing home and takes her there? So if not that, then what? Yes, right. Is it court of protection at this point? Well, that's where we're going to. So eventually we get there, after a bit of a process of trying to convince her to go along with the move. They can't do it. So the local authority does what it has to do then to resolve this issue, which is that she's refusing to go, and they think it's really important for her to go because she's really at risk in her own home. And so they issue legal proceedings in the Court of Protection, which is the court that deals with these kinds of disputes and finely balanced issues, uncertainties around mental capacity and best interests. And one of the key things in her case is that she's in her own home, and the local authority has no power of entry into that home to remove her unless it goes to the court first. So you can't, as a local authority, you can't just go and extract somebody from their own property that is, they've got their own property rights over that place. I think she owned it. I think it was her own home owned as opposed to rented as well. But either way, it makes no difference. You've got no right of entry unless you get a court order. So they have to go through the court process to do this. It's a very significant interference with her rights to take her away without her agreement. So they're seeking the court's permission to take Mrs A from her home against her wishes and place her in a nursing home in her best interests, which is not what she wants. So that's the process that you follow. So they issue legal proceedings, but then a thing happens. And the thing, if you want to call it that, is Mr. B, who is Mrs. A's son, who has been in Africa doing missionary work and returns and moves into Mrs. A's house, and he becomes her primary carer. So the care agency is still going in, but of course they were concerned about the times when they weren't there. But now Mr. B's there. So suddenly, with legal proceedings underway, the picture changes, and although it's quite new and feels a bit, feels a bit new and a bit fresh and a little bit, we're not sure about this, it seems to be working, and everything kind of calms down. And the court at this stage says, right, there's no need then, is there, for it to be removed, because we've got an arrangement that seems to be working, at least for now, with Mr. B there. So, everything's okay, isn't it? Right, can you see where this is going? So, well, can you? The year is 2021. What could possibly happen next? Somebody said COVID. Mrs. A has not been vaccinated against COVID-19. And the professional opinion of those involved with her is that she would really benefit from vaccination, which is the general view, right? COVID-19 vaccination. So, so what do we have to do then in that case? Ask her. Okay. Yeah. Yeah.
Yeah, see if she has capacity for that decision.
Yes. So the answer is we start again at the beginning. So all those, I'm not going to go and start again at the beginning, but all those slides that we've been through around capacity, we have to start again with that. Because remember, this is a different decision. So we have to start again with mental capacity. We've got to address her mental capacity then to make this decision around vaccination, which some people refuse, or some people consent to. In fact, what we need is either her consent or a best interest decision. So he said, yeah. We need her consent, or maybe it's in her best interest and she'll go along with it. So we kind of come full circle. But is this, bear in mind, the local authority are leading on this. Are they the right people to do this? Who's responsible for vaccination? Oh, somebody said GPs. Does everybody agree? It's definitely GPs, right? Yeah? Well, is it? Vaccination is weird because it's not actually clear who the decision maker is for vaccination, because it's a system-wide approach. There's no single organisation or individual that's responsible for vaccination for an individual person. They've got the whole system working together and different bits of the system doing different things. So it's quite odd. But vaccination, if there's an issue about it, it's normally litigated in the Courts of Protection by the commissioners, the ICBs now, CCGs as well. But GPs aren't directly involved in this, and actually I think GPs have a really key role to play in it for reasons that I will come back to if I have time, but I'm running short of time. So, the issue of vaccination comes up, and what do you think could possibly go wrong?
Some doesn't want it to have it.
Some doesn't want it to have it. So, the local authority raises it in the proceedings, at which point Mr. B, who is a Messianic Jew, I think is how he describes himself. I've never fully understood what that is. I did look it up at the time. It is a thing. That's how he describes himself. And he is completely anti-vax. Right? He's not happy about this. He takes strong exception on religious grounds. He unilaterally cancels all the care calls and the day centre visits that Mrs. A's been having. He refuses all professional access to the home. He's very hostile towards services. He refuses to engage in the legal proceedings. He denies that the court has any authority over him or his mother, which is a classic. Never works, that argument, by the way, if you're thinking of trying it. And he says, amongst other things, I will protect my mother to my own death. We don't need your interference, as I believe you will be invading my human rights as well as my mother's to live a peaceful life. Due to COVID-19 still being transmitted, whether vaccinated or not, I'm not allowing anyone in the home. So his anti-COVID protective measure is just to shut the doors. Turns out he's also a bit of a bad egg. Forensic history, 10-year prison sentence for GBH with intent, drugs convictions, and there's a history of safeguarding referrals involving the two of them, which for some reason didn't come to light earlier when the judge was reassured about Mr B being in the home. Never got to the bottom of that. Mrs A is briefly seen by professionals and seems well, but on occasion she also says she doesn't like him. We don't know quite who she's referring to, but the social worker senses that she's uncomfortable with Mr B being there. So what now? Hand up.
Can I just link it to adult family violence and domestic abuse?
Yeah.
Come through on earlier.
That happened earlier, didn't it? I was going to say that. I knew you'd heard about that. Yeah. So exactly. So here we go. So this case is completely turned on its head. I act for the CCG in this case, and we're brought in relation to the vaccination issue. And there are now two issues. There's where Mrs A lives and the care she receives, and there's vaccination. And I'm going to have to cut to the chase now because we've fallen short of time with some of the IT issues. But we're brought in now. There's a vaccination issue to deal with down the line, but before we get there, the court has to deal with the situation in the home, where Mrs A is, you could say, a prisoner, basically. I don't think that's putting it too high, to be honest. Mr B is completely controlling her life, not letting anybody in. The social worker can knock on the door, and he'll open the door, and the social worker will look over his shoulder and try and wave at Mrs A, but that's all the professional contact that can take place. It doesn't go beyond that, so we're really worried about it. But Mrs A's representatives, she's got legal representatives in the proceedings, they're concerned about her wishes and feelings. This is her house. He's moved in. Not his house, it's hers. She's a prisoner in her own home. So if she's going to be removed, they think that's pretty unfair, because he's left then in her house. She never wanted to leave it. Potential use of restraint to remove her. Police involvement, if Mr B reacts badly to steps being taken to remove his mother. And what are the possible alternatives? So all of that has to be thought through in quite some detail.
Can you evict her son first?
Can we evict the son? That's a really good question. I think the difficulty with that is it would take some time, and it's legal proceedings that she would have to commence. So her lawyers would have to commence legal proceedings to evict him, and it takes a little while to do that. So it's possession proceedings, which I know from experience will take ages, and it's more urgent than that. Plus, bear in mind that even if she's at home, she's already felt not to be very safe there. The only reason the ship was steady was because he turned up. So you've still got the kind of vulnerability, self-neglect issues, even if you extract Mr B from the property. To cut to the chase, so this case took quite a while to resolve, but we got there in the end. The judge had to do some wrangling in relation to Mr B's involvement, because we didn't want to tip Mr B off that we were going to try and remove Mrs A against his wishes. So there were hearings that he wasn't invited to, and that's a pretty serious step, because it directly affected him. His rights were in play too, and he wasn't in the room for those hearings. But the judge deemed this sufficiently serious to exclude him from some of the hearings. At first, the judge said, I'm not going to make orders for immediate removal of Mrs A, because I think Mr B needs to at least be given a chance, a final chance, to stop doing what he's doing. So injunctions were made telling him to open up the property, let carers in, final demand, basically, comply with what we're saying, or, we'll do something more draconian. He was given that opportunity, the orders are made, the social worker served them on him, posted them through the door. He did not comply. And so then the removal is authorised by the court, and Mrs A is taken away from her home. I'm pleased to say that she went willingly in the end, or at least she complied. It's not what she wanted, but she complied. Mr B just about behaved himself on the day, although we were the police on standby just in case he did something daft. And she settled well in the nursing home, where then the CCG could work through all the best interest stuff around vaccination, which would involve quite close liaison with the GP, actually, looking at her clinical history, what vaccination she'd had, what her views were generally about vaccination and about medical treatment. Was she the kind of person that had her flu jab every year? She was. So vaccination went ahead, and Mrs A came out of it well, albeit not in her own home, but she settled well in the nursing home. And that is more or less the end of the story. So I'm going to stop there. Although, if you get the slides after this, you will find there is a link there, Hull City Council and Mrs A and others from 2021, which gives you a bit more detail about what we did and why and how everybody played their role. And I think the key message about it is, aside from mental capacity and the decision-making stuff, which is really, really super important, it's about team playing. There's an enormous number of individuals, professionals involved in this, all of them working closely together, including in general practice, which was great. The GPs were really good in this one. And that's the thing to remember, is if you become aware of somebody in your area who you think is vulnerable in this kind of way, escalate it and work with colleagues to try and get a better outcome for them. And that's it from me. Thank you very much. Thanks for bearing with me.